And now I will ask Rebecca John to join us. Rebecca was designated as senior advocate in 2013. She enrolled with the Bar Council of Delhi in 1988 and has been practicing exclusively on the criminal side in Supreme Court of India, High Court of Delhi, and the trial courts of Delhi for more than 3 decades. She has conducted a wide range of criminal trials and argued appeals dealing with the offences under the Indian Penal Code, Unlawful Activities Prevention Act, Prevention of Corruption Act, and other special statute. Over the years, she has represented accused persons as well as victims. Amongst the long list of cases to her credit are the Jain Hawala case of 1996, the 2G Spectrum case, the Arushi Talwar case, the criminal defamation complaint filed against Priya Ramani, that case is going on, the Ankit Saxena murder trial, where she has been appointed as special public prosecutor, and many others. She is member of Internal Complaints Committee of Delhi High Court, dealing with complaints under sexual harassment of women at workplace Act 2013. She is also a statutory member of Delhi High Court Legal Services Committee.
What I'm going to focus on is the questionnaire. And I must say that when I look at the questionnaire, we're now at the 6th tranche of the questionnaires. I come out feeling terribly confused, and I wonder what this exercise was all about. Essentially, I would divide the questions into 3 categories. There has been an over-reliance in the questions on forensic evidence, and I think from there we can determine where this is going forward. And I'll come to that in a short while from now. There have been certain interesting formulations which have been thrown at us, but no follow-up questions after those formulations have been put across. And lastly, there have been a whole range of questions which betrayed a complete lack of understanding of criminal law. And if I may be permitted to say, was stupid and unintelligent. So we were compelled to answer some of these questions as well. Coming to the first lot of questions which I want to focus on, the over-reliance on forensic evidence. And I think this is important for us to flag because I think this is where criminal law is going to go from here onwards. And so in the questionnaire related to the Criminal Procedure Code, as well as to the Indian Evidence Act, there has been a lot of questioning about modification to the rules of evidence pertaining to expert evidence. There have been questions relating to formalization of voice samples, questions relating to your cell phone and passcodes and passwords and whether these can be made admissible in evidence. There have been, of course, questions where I don't know whether there's been a full understanding of it, but in Part E of the first consultation on the law of evidence, there were questions where a rather ambitious question was asked about the US standard for appreciation of forensic evidence, which is otherwise known as the Daubert test, and whether we can have a parallel acknowledgement in India. Now, all of this is very well, but what these questions betray is a complete lack of understanding about forensic and scientific evidence. And that is firstly, and we've attempted to say that in our answers, that science is not free from error, and what you think is unimpeachable scientific evidence is already evidence which has been junked in other countries of the world. You'd be surprised to know that in Mukesh versus State, the case in which the Delhi, the men with respect to the Nirbhaya case were hanged to death, the Supreme Court actually took into consideration odontology evidence, which has now been junked as junk science across the world. And post that, the Supreme Court said that in rape cases, we must perhaps look into evidence of this nature. So it was very important to flag that some of these scientific evidence, which you think is great evidence, is actually not good scientific evidence, and it has actually been has been jumped in other jurisdictions of the world. The questions betrayed, while they asked about the Dauber test, they did not understand that in India, there is absolutely no adherence to the rule of foundational validity and valid application. So for a particular science or for a particular test to be admitted in court, it is incumbent on the forensic science expert to show the foundational validity of the science. And if he's not able to do so, such evidence must be jumped. And which is why traditional law in India, with respect to handwriting, with respect to voice samples, has said that this can only be corroborative evidence. It can't be substantive evidence. And somewhere, I think the questionnaire forgot that there is constitutional bench judgments of the Supreme Court which says that handwriting reports and other forms of forensic reports can only be corroborative. And in the absence of substantive evidence, to use them for purposes of conviction would be very, very dangerous. The questions also betray an understanding of ground realities in the country. For example, you are talking about uplifting forensic science evidence with about 40 forensic science laboratories across the country. How do you do that? So really, the state does not want to invest either in laboratories or processes or infrastructure, but the state wants to elevate the evidence to a status where it becomes the sole basis for conviction. So that lot of questions, I would say, were very dangerous and were frightening, because not only did it betray a complete lack of understanding of ground realities, it also betrayed a complete lack of understanding of how such evidence is viewed in other jurisdictions. And the tendency in India to not question an expert and to take an expert's evidence as gospel truth was betrayed in the line of questions that we had to answer with respect to forensic evidence. Moving on, there was, I felt that a lot of the questions started with, can you tell us what are the guidelines for such and such things? What are the guidelines for sentencing? Or what are the guidelines for before a court can decide whether something is an interlocutory order or a final order? And it compelled one of us to say in one of our informal meetings that perhaps they want to give a guidebook to judges rather than engage in a serious law reform process, because guidelines can never be part of statutory amendments. Guidelines are guidelines, and you may refer to it in the form of handbooks, but they can't be introduced in the form of statutory amendments. And it became so bizarre at one point. Questions were asked as to what is the time limit that a court will take to give a final judgment? For how long can a judgment pertaining to an interim application be kept pending? What is the time limit before for a forensic expert to come and give its report before the court? Now, these are not questions for which amendments are required in the law. Surely the Indian Evidence Act or the Code of Criminal Procedure is not going to bring about amendments focusing on time limits. These are good practices which the courts must adopt. And these practices are also incumbent on the fact that you must have sufficient number of judges who are able to deal with the workload. As you know, the case judge ratio in India is so skewed against the litigant, and there are so few judges in this country. So when you ask questions pertaining to time limits, you are actually forgetting that reality. And lastly, there were these interesting questions which were asked, but there were no follow-up questions, and I'll deal with some of them. One was, of course, a question which related to illegally obtained evidence, which in the West is called fruits of a poisonous tree. And they wanted a definition on evidence which is illegally obtained. They wanted exceptions to such rule, and really it was someone who had studied or who had referred to the fruits of the poisonous tree doctrine pertaining to America, and wanted to bring it into our jurisprudence. I welcome that question, but it must have follow-up questions. At what stage will that become admissible or not admissible? America has a very different way of conducting trials. They have evidentiary hearings and admissibility hearings right at the start of a trial. We don't have those. We don't have those stages in Indian trials. So can you bring about these kind of changes without parallel changes in the trial, or are you again looking at something which Indian courts do anyway, and which is to decide the admissibility of a particular piece of evidence at the very end of a trial? So some of these questions were interesting, but there were no follow-ups to it. Likewise, there was a question, at least in our group, we disagreed disagreed a lot on that. Some of us agreed not to answer those questions, and this was on plea bargaining. And a list of 4 questions were asked. But our response, at least I can speak for the 3 of us in this panel, our response was that the concept of plea bargaining ignores the harsh socioeconomic realities of the Indian criminal justice system, and quality legal assistance comes at a cost which the poor and the marginalized accused are unable to afford. The remuneration provided to legal aid lawyers at present is neither motivating nor attractive. A poor, barely literate accused who has entered the criminal justice system for the first time is bound to be overwhelmed by the process and might be pressured or coerced into plea bargain, regardless of whether or not they have committed an offense. I can say this with some certainty, looking at a bunch of cases which were decided in Delhi very recently, where over 900 foreign nationals belonging to the Tablighi Jamaat were compelled to plead guilty to the charges they faced only because they were placed in that circumstance where they wanted to leave the country and go back to their home countries, not because the case of the prosecution was in any way credible or that there was any credible evidence against them. I suspect that if they had stayed back and contested the trial, most of them would be acquitted. So why are you bringing in plea bargain? I mean, would a rich, entitled litigant faced with the choice of contesting a trial or pleading guilty at the start of a trial, what is the option he will exercise? And the answer is very clear. He will exercise the option of contesting the trial. So it appears to us that this was the objective of plea bargaining at the time of its introduction was simply to reduce the pendency of cases, and that can't be the moral objective of a principle of this kind. But in the end, the system of plea bargain, it ends up penalizing the already marginalized and vulnerable accused for their poverty and other forms of despair or hopelessness, such as force of circumstances, by coercing them to plead guilty, sometimes for crimes they have not committed. And yet, there were a list of 4 questions which were asked, that how do we improve the system of plea bargaining without recognizing this basic socioeconomic reality. Aside from that, for me, this whole process, please remember that on the mandate of the committee, as per the public notice dated 8/7/2020, was that to recommend reforms in the criminal laws of the country in a principled, effective, efficient manner, which ensures the safety and security of the individual, the community, and the nation, and which prioritizes the constitutional values of justice, dignity, and the inherent worth of the individual. Now, if this was the stated objective of the committee, and it was looking at reforms in the criminal laws of the country, I'm a little intrigued why they only stopped at the three basic laws defining criminal law, which is the Indian Penal Code, the Code of Criminal Procedure, and the Indian Evidence Act, and did not expand its ambit to the special laws, which have now become the norm. The general law has been pushed to the back burner. The special laws have become the norm. And if your stated objective was to reform the criminal laws of the country, I would have expected questions on the UAPA to be asked, questions on MACOCA to be asked, questions on the Prevention of Money Laundering Act to be asked, and a range of other special statutes to be asked, which was not asked. Whoever told them that their brief was limited to just these three principal criminal acts, and why didn't they expand their stated objectives to these other special acts? Take, for example, the UAPA, which has so many problematic provisions. For example, 43D2, where the period of investigation can be extended from 90 days to 180 days. Even at the end of 180 days, you do not get a charge sheet because you're arresting more and more people. And the 180 days extends to as many people that you are arresting. And so it is an endless process. Surely that is linked to the criminal law amendment process that you have undertaken, particularly because the UAPA seeks to amend a fundamental provision of the Code of Criminal Procedure, which is 167, and that is the period of remand. Likewise, the provisions relating to bail in the UAPA, which is 43D5, has not found any mention in this law reform process, which makes bail a near impossibility, because the judge granting bail has to literally certify that there exists no prima facie case against the accused, and which judge is going to do that? Also, the judgment of the Supreme Court in NIA versus Zaroor Ahmad Shah Batali has made it almost impossible for UAPA accused to get bail. Surely these were things that a credible law reforms committee should have thought about, and there should have been more engagement with respect to special statutes. And there has been virtually no mention of special statutes. And this I say because, as per the NCRB data, from 976 cases in 2014, we have now in 2018, the number of cases has risen to 1182 under the UAPA. And as per the data available with the Ministry of Home Affairs, from about 3,005 cases which were registered in the country over the last 3 years, only 821 charge sheets have been filed within the statutory time limit. So this is a question of tremendous importance, and the committee shirking any discussion on it, I would say, is one of its greatest failures. Now, the scope of special legislations has been expanding over the years, and different evidentiary standards and procedures are being formulated in the garb of these statutes. The exception has become the norm. These special acts are, strictly speaking, I would say, immoral, illegal, unconstitutional, because the burden has shifted from the state to the citizen to prove his innocence. Even basic evidentiary norms for the acceptance of evidence has changed in these statutes. And therefore, when you are discussing amendments to the Criminal Procedure Code or the Evidence Act, it was necessary to speak about these special acts, because these special acts seek to amend basic principles given in the Code of Criminal Procedure and the Evidence Act. And therefore, to restrict the scope of the criminal law reform to only 3 principal statutes ignores a harsh reality of criminal prosecution in India today, where a large number of serious offenses actually do not pertain to the Indian Penal Code, but pertain to these special acts. Therefore, in fact, I feel I can end this. I know there's not much time. the very first question which was thrown at us was which principles regarding the object and nature of crime should govern the introduction of strict liability offenses within the IPC. And now, strict liability offenses within the IPC, the two are the two are poles apart, and IPC offenses require mens rea, which is a mental state of mind, and to ask a question as to the principles governing the object and nature of crime, which are those principles which will guide the introduction of strict liability offenses within the IPC, I think was a message to all of us, because you have virtually introduced strict liability offenses through these special statutes. You have virtually said, if you are a member of an unlawful organization, you will be prosecuted and your sentence will be life. Where there is no obligation on the prosecuting agency to show that you were a member of the unlawful organization that they claim you are a member of. It is for you to show that you are not a member of such unlawful organization. So really, you've introduced strict liability through these special statutes. And it is the special statutes which hold the field at the moment. And so the very first question that was thrown at us gave us an indication of where this was where this was going. I'll end by saying that any law reform process must be a moral exercise. We are as Vrinda so rightly said, laws should empower the citizens. Laws must not do violence to the citizens. Unfortunately, the reverse is happening. And this exercise has not in any way assuaged our fears. We continue to believe that laws will be used for purposes of punishing the citizen for crimes that she or he has not committed. Thank you.
थैंक यू रेबिका, आपने बहुत ही महत्वपूर्ण बातें बताई और हमारे सामने जो एक बड़ा संकट आके खड़ा है उसके बारे में हम सबको जागरूक किया। खास करके सबूत के ऊपर आपने बहुत ही इम्पोर्टेंट बातें बताई। और जैसे कि आज हम देख रहे हैं कि यूएपीए के केस में बहुत सारे लोगों को अंदर डाला है, और जब तक उनका केस, कुछ लोगों का 2 साल के ऊपर अंदर है, कुछ लोग 5 साल से अंदर है, और उनके सामने अभी तक केस भी चालू नहीं हुआ है। दूसरी बात ऐसे है कि ऐसे सबूत उन्होंने इकट्ठा किए हैं कि जैसे कि हार्ड डिस्क, उनकी कॉपी तक लोगों को दी नहीं है, 1 साल लगा कॉपी देने में, और वो कॉपी में किस तरह से उन्होंने गड़बड़ की होगी इसके ऊपर किसी का भी भरोसा नहीं। क्योंकि हमारा आपने जो सबूत के बारे में बताया, वो असलियत में केस शुरू होते ही ये केस बंद होना चाहिए था, क्योंकि वो सबूत ही ऐसा है कि जिसके ऊपर कुछ जिसको बोलते हैं कि उसका बराबर कॉपी वैल्यू के साथ, हैश वैल्यू के साथ, अक्यूज के साथ होना चाहिए। वो प्रोसेस भी नहीं हुआ है, लेकिन केसेस चलते रहे हैं।